lounge to review draft policies or legislation, or to probe other matters of serious national importance. Members of these committees are both opposition and government MPs and senators, and these committees will usually invite citizens to share their opinions, concerns, and recommendations. So there you have it, 4 accountability tools of Parliament that are used to make sure government run right. Visit jampja.org to find contact information for your MP. Invite them to meet with the community so they can better represent your issues and concerns in Parliament and keep government accountable. Get involved and let's make Jamaica land we love, Jamaica land we own, and Jamaica land we run well. A message from the Jamaica Accountability Meter Portal, funded by the European Union and the Inter-American Development Bank in partnership with the Private Sector Organization of Jamaica.
Policy for which there's need for elucidation and for the committee to be fully apprised of in terms of how the future will go, certainly in terms of these reports that are coming to us and how we will be able to evaluate them and report appropriately to Parliament in accordance with the standing orders. Apologies. Member Charles has tendered apology. Any other apologies? The minutes are before you. Do I have a confirmation? Member Malahoo Ford, seconded by Member Robinson. Matters arising from the minutes. I believe those matters would be the 6 reports now that are before us. So shall we invite the members from the Commission to come inside? Yes. I made that point. Yeah, so while we await the attendance of guests from the IC, we want to acknowledge and welcome students from the Porus Primary School who are here in the gallery with their teacher, yes, and very nice to have you. I think it is a correct thing to see. Young, particularly children at the primary, in fact, even at the earlier stage, to begin to understand the democratic process and perhaps the institutions which give efficacy to these principles. So very happy to have you, and I hope you learn a bit today and you'll be able to write essays later on when you go back to school. Thank you, teacher, for bringing them. And I saw earlier where good instructions were given and lecture even on the workings of Parliament and what the Westminster system is all about and so on. Start very early. You know, interestingly, the practice of embedding at an early age the principles of democracy is very important for the future of that very institution. And I went to Costa Rica a few years ago to participate in the invigilation of their elections and so on. And what was interesting is that children voted. Yes, that children, any age, it's just a mock election so as to embed this principle of party. A mock election, yes, the children voted. So, no, but they voted. They didn't vote in the adult election, but they had. And that I thought was a very good way of ensuring that the internalization of these wider principles of democracy was had. So, again, welcome.
You know, children are treated specially in law because of the recognition of their susceptibility to influence by third parties. So I'd be curious to find out, you know, how the voting went, but you clarified that it was mock voting to prepare them to be acquainted with the process of voting.
Yes, yes, indeed. Okay, so we have the team from the Integrity Commission here, led by Mr. Craig Beresford. So shall I ask him to do the introductions? Am I correct that, Craig, you lead? No? Oh, Kevin. Yes, 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 yes. Oh, sorry.
Good morning, Honorable Chairman and members of your committee. The Chairman of the Integrity Commission, the Honorable Mr. Justice Seymour Panton, has asked me to convey to you and the members of your committee his regard and hearty greetings on behalf of the commissioners and the men and women of the Integrity Commission. We are delighted to be here this morning and look forward to a very meaningful engagement. In the same breath, I pause to introduce the members of the Commission's team attending this morning's proceedings, three of whom, of course, are no strangers to this honorable place. I am Kevin Stevenson, Director of Investigations. Also before you, Chairman and members, are Mrs. Keisha Prince-Kamika, the Learned Director of Corruption Prosecution, Mr. Craig Beresford, Director of Information and Complaints, and Ms. Kishna Chambers, who is Administrative Assistant to the Director of Investigation. The Integrity Commission Oversight Committee is an integral part of the overall scheme of the Integrity Commission. And the impact of the committee can only be made all the more significant through engagements such as these. It is on this basis that your invitation of May 6, 2024, to appear before you this morning to participate in your deliberations concerning 7 investigation reports was well received by the Commission, and we look forward to assisting the committee in any way that we can in its deliberations. We therefore now place ourselves in your capable hands, Chairman. So over to you.
Thank you, Mr. Stevenson. Thank you, Mr. Stevenson. Now, members, you've heard the overview by Mr. Stevenson, and the floor is now open for any questions that we have on these 6 reports that are before us.
I join you in welcoming the directors and other staff of the Commission. It was, however, my understanding, Chairman, that the commissioners would have been present at today's sitting, and while I noted the greeting from the Chairman Commissioner, I did not hear any apology, and I wonder whether there is some misunderstanding on my part as a member of this very important committee. I wait to hear whether there is a misunderstanding on my part, but just to say that for some time now, as a committee, we have spoken about having an interaction with the commissioners themselves, as important as it is to interact with the directors and other staff. And we certainly would not want the impression to be given that as servants of the people, we are not availing ourselves to discuss the matters of the people at all levels. It really was my understanding that the commissioners themselves would be present today. And Chairman, although I arrived before the start of the meeting, I did come here after 10 o'clock because I had to rush from the post-cabinet press briefing to be here. I would have been here anyway, but it was my clear understanding that the commissioners themselves would be here. We can't have a perception being strengthened that there is either unwillingness or inability for the commissioners, as commissioners of the Parliament, commissioners of this Commission of Parliament, not being available to discuss with us matters. While we are undoubtedly willing to engage with the directors, we believe that it's important for the commissioners themselves, Chairman, to be here. And please correct me if I am wrong in my understanding and expectation that this morning's meeting would have been an engagement with the commissioners themselves, even if they are supported by the staff of the commission.
So in clear response to that, your understanding is not unfounded by any means. In fact, the letter indicated that we invited the chairman and whoever else he wished to take with him. My own understanding too, but we've had a discussion on that, and the clear understanding that I have now is that the chairman is willing to engage. Today might have not been as convenient as possible, but he is willing to meet with us as he ought to, because the requirement is clear. It says that Section 5.4 states that the Commission shall be ultimately responsible for and accountable to Parliament for all matters relating to the function of the Commission, and B, monitor and report for Parliament on the operation and effectiveness of the provisions of the Act. So it is very clear that it is the Commission that has the final responsibility. Now, the Commission can and have done in the past, arrogated to directors so as to make for a more efficient operation and for us to get a more direct response, because they are the ones who do the actual day-to-day work. And so, for greater clarity, but broader matters of policy, which are underpin the actions that these directors take, have to be dealt with here. And that's what this body is about. So I will further make a call for a meeting. I'd like to ask us to leave it at that for the purposes of today.
No, Chairman. First of all, it's clear that there must have been some understanding that the commissioners would be here, because name cards have been prepared. I see one there for Honorable Seymour Panton. So
sorry, I want to clarify, not the commissioners,
well,
but the chairman of the commission, not commissioners.
To be frank with you, Chairman, I think the commissioners should be invited. And the reason for that, we don't mind dealing with the directors, especially to clarify, details of matters. But I think the Oversight Committee and the country would like to get some understanding from the commissioners. What are the policies overseeing the Integrity Commission? Because, and I say this because at the end of the day, as I've said before, we want the IC to succeed. We want corruption at all levels to be reduced and eliminated. And therefore the question is, are the policies being pursued by the IC likely to get to that result where we see, for instance, even if we use Transparency International, that for the last few years have given us a score of about 44. Is the IC looking at those scores and see how can we increase it to 50 or 60. So we, at least say that corruption is being tackled on a wider level. But more importantly, since the 2018 Act, when the Commission, the different levels, the Corruption Commission and the Integrity Commission and the Contractor General were subsumed into one. You really need to hear from the commissioners themselves if that, for example, is a good thing. I remember it was challenged, but is it working out well? Are there some aspects of the Contractor General's law, for example, that should have been included in the present integrity legislation? Because we are now another committee consisting of many of our members are looking as to how we can adjust the present Integrity Commission legislation to make it more effective. So you certainly would like to hear from the commissioners, exactly what would be useful, so we can have that sort of discussion. So while Mr. Stevenson, Mr. Brent, and Ms. Keisha, Kamal, we don't mind having you on to get into detail. The commissioners themselves need to give us broad outlines of policy, because I can tell you that there are many MPs and public sector employees who complain to us that, there are certain direction that they see the IC is going, which they want to know if that is an appropriate policy. As an example, is it appropriate that if I'm elected in 2020, that I should be asked questions about any of my dealings in 1990, which, MPs have complained about? I was only elected in 2020. But I've been asked about interactions or contracts I engaged in 30, 40 years ago. So is that an appropriate policy? Or is it more appropriate to say you're looking at your transactions, say from you were elected, and what do you hope to achieve, by asking for information of the public official about matters which in their private capacity they were engaging. So people have been saying, is that a policy of the Commission that they can go back? Then again, you have persons who have certified declaration, and they've been certified maybe up to 2018, 2019. And then all of a sudden, for the last 2 or 3 years, matters that occurred before 2018 when they were certified, they're being asked about those matters now. So the question is, what is the policy? I mean, we haven't been, the public official haven't been certified, say, continuously up to about 2018, which is, then all of a sudden, with the new act now, they're not certified, say, 2019, 2020, because questions are being asked about transactions or matters they had 10, 20, 30 years before, even though they had certification, in 2018, up to that point. So, Chairman, I believe we need to get the commissioners to give us some policy directives.
So thank you, member, because you were very extensive in your explanation of the very point that we made earlier, that yes, we will have the commissioner, the chairman for sure, because we had that discussion. And I take it that today something went awry, but I know that it will happen, And we have had that. And for the very reasons that you have elucidated, and he's quite aware of that. I'm not speaking on his behalf by any means, but I just want the point to be made that he did not express an adverse position with regards to attending on this committee.
Chairman,
let him go ahead. A substantive matter.
a lot of what Member Chuck is speaking about are issues that should be dealt with in the Oversight, the review committee. So where there are weaknesses, I think it's our duty to correct them. And where policy is concerned, we are supposed to write them. So the question is asked, and those are questions and issues that I believe we ought to deal with in the other committee and lay it out clearly. The other issue is you mentioned this thing about going way back. There's no institution, nothing at all, that have any remit in dealing with the issue before you were established. They were established on the 23rd of October 2017. They have no legal authority to go beyond that date unless there were investigation being done at that time by the Contractor General or any of those bodies that were subsuming to this one. There's no legal basis on which they can do that. None at all.
To the need for us to have the commission before us, and that will be made to happen, absolutely under my watch. Member Robinson.
Thank you. My question is directed to the Director of Corruption Prosecution. Is it the norm when you're making a ruling one way or another to provide reasons for that? I ask in relation to the report of Ms. Ava Williams, manager of Jamaica Customs Agency, where a decision was made not to prosecute. It seems on the surface, without more, inconsistent with other decisions that have been taken to prosecute other persons for similar offenses, or I would say offenses that would not even rise to what I've seen here. So my question would be, what would be the reasons in this particular case, and generally, when you make a ruling one way or another, do you provide those reasons so that we understand the basis of your ruling?
Chair and members. Yes, Member Robinson, insofar as a decision is made to charge or not, a ruling is passed through the executive director to the commissioners. That ruling, however, is not published, only the indication as to whether or not a charge will be laid. In particular, the Ava Williams matter had certain challenges on the documentation that were served on her. It was in furtherance of a Section 41(6) notice and discharge liability notices that were issued. And on assessing the evidence in support of that, of the offense, it was determined that these errors actually went to the elements of the offense. And as such, that was a decision taken. So that is how it's distinguishable from other matters. It's not arbitrary.
I think it's important then, even if not the full decision, at least a summary should be provided to us in the Parliament, because when I look on it without knowledge, I'm trying to determine why go charge X person and why not charge Y. And you clearly have very solid reasons for it, but that's not shared with us. So either, and we may get to more serious offenses in the future, so I believe the Commission, and I believe this is within our remit, Chairman, that the decision of the Director of Corruption Prosecution should be shared with the Parliament when the reports are tabled, not just the summary to say whether you're charging or not, but the reasons, so that people can know why you have made a decision one way or another.
Right. Sorry, go ahead.
That is well appreciated, Member Robinson. And in fact, representation has been made and discussions have been had internally with regard to such a policy or the approach of the Commission. It really is an issue for the chairman.
No, I believe this is within the remit of the Oversight Committee. We're dealing with procedures, we're dealing with processes for transparency, good governance, and frankly, to protect you against unfounded allegations. We must make a decision that be sent to the Parliament and not just the summary. I don't think it is for the commissioners alone to determine. I think we can make that recommendation.
I think that makes the point about having the commissioners before us, because that's how broader policy arrangements can be, achieved. So I just wondered whether there was any further information that would come to us with regards to this very matter of Ms. Ava Williams, since the recommendation on page 15 of the report did say that the Director of Investigation recommends that this report be referred to the Director of Corruption Prosecution for consideration. So when that consideration is made, would that report then come to us?
Well, the ruling is what would have been provided, indicating the position. What is sent is the indication as to whether or not there's a charge. Mm-hmm. And that would have been done by the Executive Director once the report is tabled, to say that by virtue of the deliberation of the Director of Corruption Prosecution, mm-hmm. that this decision has been taken, but not the details.
So it is a fair assumption on the part of the Member Robinson, that the matter has been rested because there is no action that has been indicated here on the part of, because the consideration is.
What is provided to us is a decision as to whether to charge or not. Mm-hmm. I am saying that is not sufficient. I would like the reasons, because we are, frankly, this might be a minor matter. Mm. We're going to get to more serious matters at a later stage with more prominent individuals, and it's important for the public to know the basis on which you act. And I think it will protect the Commission if you make those decisions, you send them to Parliament with the ruling.
Chair, I'm just reminded that the posture of the commissioners is that generally rulings are not issued unless, as in the Westcon matter, there is a need for that to happen, but generally rulings are not provided.
It reinforces your need for the commissioners to be here, but I'm saying we are empowered as parliamentarians on this oversight committee to make recommendations, and I'm strongly recommending, very strongly, that it be provided. And it is to protect you from accusations of arbitrariness and bias, because without more, that is the conclusion that people will draw when they just say that, oh, one person don't get charged, but another person get charged, and they have no other basis for forming a conclusion. Now, clearly, I understand if you are going to charge, some information needs to remain confidential because you're going to a court of law, right? I understand that. But I believe even if it is a summary, but more must be provided in these cases because, as I said, this one, in the scheme of things, is minor. Others going to come, and people going to question. And transparency is important.
May I just ask Member Robinson? Member Robinson, I think we have to be through you, Chairman. If your request is when a ruling not to charge, I can understand that. But I don't think it would be appropriate to give reasons why you charge, because as you quite right to put it, it may end up in court. But because not to charge could be the end of the matter, you know, because it won't be going to court. Is that your position? Just for a sum of reasons why not to charge, but not the other way around. If there's to be charged, I don't think you should be given reasons, because in those circumstances, it's a matter for the court.
On the issue of to charge, I understand the need to be protective of either information which may be evidentiary, but I would also say I believe it is also going to be important maybe to provide a summary of the reasons, all right? And that's something that requires some consideration. I'm certainly firm on the view of if you're going to not charge, definitely. But if you are going to charge, I also think it's going to be important. The people who we're dealing with here there are us as parliamentarians, senior public officials, and I think the public, before a matter even gets to court, will want to know a basis. And if you can't give all the details, a summary, I think, is important.
Thank you very much, Chairman. I think the issue of the chairman's appearance this morning has come up, and I know you've said that you had discussions with him. Just to indicate that there was an indication to Ms. Bailey as to who would be attending this morning. So it's not a matter that the chairman just didn't show up. So I just wanted to make that clear,
No,
that the letter was sent on it.
I deliberately not go any further in that discussion. Thank you. So I think Member Robinson's point is well taken. And I think that one of the things we can look at is when the commission will come before us in terms of that broader policy, that these areas be dealt with, as you have correctly said, that it is not in your remit. Yes, and I understand very well.
Yes. Thank you very much, Chair, and good morning, members. I would just like to add to this particular matter. I recognize what the Minister of Justice said about him and this committee assisting us and wanting to see us being successful, and that's very important, and very happy to hear that. We would have made a recommendation in our 2021-2022 annual report, and it touches on this AVA matter, and it speaks to actions of the Commission not void for want of form. Now, this is a simple matter, but there may be other complex matter that something as simple as a date can cause a case to break down if a date is wrong. And we had asked, and I'm going to quote, the Integrity Commission Act has repealed Section 22 of the Contractor General Act, and no subsequent and equal provision has been provided. Given the complexity and variety of matters being treated with by the Commission, it is recommended that the Act be amended to include the provision that the proceedings of the Commission and/or the directors shall not be rendered void for want of form. It's very important, because a simple matter, as we said, as a date, if we have a major corruption issue, can break down as a result of that simple date error. And I just want to put that back on the table, that I know it's not this committee, it's the committee reviewing the legislation, that they look back at this recommendation. It's a very important one.
Just to let you know, I'm wearing another hat. It's being looked at. Yes. I just wondered for the member Malahoo Fort might want to opine on this, because I believe at another place she spoke very eloquently on the issue of form. Very well.
To say, Chairman, that as Member Chuck has said, and you have repeatedly said, and I think other members of this commission, we are interested in integrity in public life. We understand the matters at hand. There are perceptions that we have to work at correcting, and the committee is desperately trying to get a better understanding of certain matters. And today's sitting really would have been better facilitated with the presence of the commissioners for us to discuss some of the policy approach being taken and where the Parliament may better assist. I am not very pleased that many times it's the combative exchanges that make the news. And we focus on the differences instead of what unites us in the cause for integrity in public life. We are all servants of the people, and none of us is above the office granted to us in service of the people. Speaking for myself, and I believe I can speak for my colleagues certainly on the government side, and I believe the same may be true for those on the opposition side, we are interested in an effective framework. We are interested in an approach that will inspire confidence in the work of the Commission and not more questions than answers provided.
Any other comment member wish to make in relation to these reports that are before us? Because we really have to make a report later today in the House so as to fulfill the 30-day requirement of the standing order. Yes, Member Woman.
I have a general concern that I raised last time, and that has to do with 42.3a. It says here, where upon examination of a statutory declaration, the Director of Information and Complaint is satisfied that the statutory declaration has been duly completed, he shall so inform the Commission, and the Commission shall, A, cause to be issued to the public official or parliamentarian, as the case may be, confirmation thereof in writing. What I want to know first, this section is quite clear. Why do we have to have a rider on it which does not? It says here the Integrity Commission, I'm reading, for example, one of the certifications they sent out. The Integrity Commission hereby certifies that your statutory declaration as of December 31st, 2019 has been examined. Based on the examination, which does not constitute an audit, it appears that the declaration has been duly completed in accordance with the provision of the Integrity Commission Act. Why there has to be a rider? Either you're going to certify or not. We don't need to know that you did an audit or didn't do an audit. The section clearly states that you should certify. The other question I have, if you give a certification for 2019, it means that it's taken that 2018, 17, 16 were in order, because each declaration really relies on the one before. The other issue, if you issue a certification, what I don't understand, why do you go back and still ask for information from that individual for the very same year, that year that you certified for? On what basis? What's the use of the certification? Does it serve any purpose? If you certify and then you go back and asking for information, or you go back and charging the person for something. So if something was outstanding to the extent where the person has to be charged or report made on that person, why certify in the first place? Does it have any relevance? Does it make any sense to them at the commission, or the Integrity Commission? If you're going to certify, then you ask for information on that year, then you're going to charge, and you're going to report in the person and so on. What purpose does it serve?
So, Member Warmington, again, these are the reasons for which we are requiring the presence of the Commissioner to speak to these broader policy issues and issues as it relates to the law. In fairness to the technical officers, they can give a view, but that would be constrained by the fact that they have to report somewhere else. And so, no, but in fairness, we've gone the route. And I think what you did say a while ago, for example, Member Warmington, it's really an expansion of what Member Chuck said earlier, and we all have agreed on. So we're going to that path. Let's go there, all right? Very well. Member Malahuford?
Thank you, Chairman. I just want to know whether the Director of Information or the Director or any of the other directors can update the committee on what has happened post-report on the public servants in question. Did any of them pay the fine? Were there convictions in the court? Have the statutory declarations in question been submitted since report? And no.
Yes, thank you, Chairman. I can take that one, Member Ford. One of the matters, Mr. Charlton McFarlane, has been concluded. He was fined. He pleaded guilty on all 4 counts for failing to file, and there was also a Section 41(6) notice that was issued. And he was fined $50,000 or 3 months on each of the 4, and $200,000 or 6 months with regard to the Section 41(6) notice. That's the one that carries the recurring $20,000 per month penalty.
My understanding is that when that notice is issued, it is a notice that takes care of a criminal liability in the matter.
No, that's a discharge liability notice. The Section 41(6) is the one where a request is made for the outstanding statutory declaration, and that offense, the fine runs for however long the offense continues.
Right. So you're saying Mr. McFarlane is now in better standing?
Yes. And right, we normally confirms. I'm so sorry. I'm sorry.
No, I'm just asking whether the outstanding statutory declarations referenced in the report were submitted.
That is my understanding. If I just might confirm, yes, those are submitted. The matter of Trevon Clark remains before the court. That matter is for mention. The matter of Dwayne Vaz, he offered a plea of guilty and sentencing has been deferred. The matter of Oral Reed is also before the court for mention. The matter of Callahan requires some outstanding material charges are to be laid, but some additional material is to be placed on file for us to lay charges. Those are my updates, unless there are further questions.
So does that speak somewhat to the requirement that you are asking, Member Robinson, with regards to further details on these matters to be presented to the Oversight Committee?
That's not where I was going, but it raises something else. So in the case of Charlton McFarlane, he has been, quote unquote, cleared. There's no criminal liability, there's nothing there. Do you issue something, either a letter or anything of that nature, to indicate that having now satisfied, provided his outstanding returns, etc., he's free? The reason sorry, let me not use the word free, but in the court of public opinion, having had that issue, quote unquote, over his head, without more, the public wouldn't know that the matter has been resolved. And in a case like his, you trade on your reputation, quite frankly. And so I believe if he has satisfied everything that you have asked of him, and he has also dealt with the court matters, I think it is important to indicate, even if it's a letter to him or to the committee, to say he has successfully dealt with the issues and there is nothing outstanding. Because again, it was particularly in this case, he was the head of the RGD, it was all over the media, and it's important that the public knows, for his own future employment prospects, quite frankly, that he has complied with what you have asked him to do.
I totally agree with that. In fact, the sense I have is that once they have discharged their obligations, then their declaration would have been certified. Once you discharge, because the whole purpose of requiring these things is to be able to certify the declaration. So having satisfied it, whether through court payments, as the case might be, or sentencing or whatever, having satisfied it, does that now make him ready for certification? And if so, shouldn't it possibly be made known so as Member Robinson correctly said, to clear the air? You know, the hard cold facts are that naming and shaming is as deleterious to the future of individuals as an actual charge in court. And people do suffer irreparable damage from that very process. Now, this is not to say it isn't to happen. It's only that so much care has to be taken in this regard, because this is about the future of people, their children, you know, their families, you know, and so many people, after being named and shamed, literally have lost their mind because they've lost their sense of person. And that is a critical element that makes you a human being of value. And suddenly they feel, oh my God, I'm no longer anybody of value, and it's over. So once the reparation is done and the process requires a clarity to the world, it does require clarity to the world. And so I agree that this chamber, this parliament should have that information as well as the public at large.
I believe a distinction.
You need a course. You're not on, you know.
Yes, that's it. No, he's not on.
You're not on. You're not.
Member Malehufort was...
just to, thank you, Chairman, just to underscore one point and then to take up something you have raised. I am suggesting that as a matter of policy, that the Parliament be provided with updates on all matters referred to for prosecution, so that we will know whether the public servant or erstwhile public servant has taken remedial action. It's the first point. The second point, Chairman, is that it is up to a declarant to comply as much as it lies within him or her to comply. It is not within the declarant's power to say whether what has been submitted satisfies the commission. And I think that distinction has to be drawn. So the obligation is to submit the statutory declaration. The obligation is to answer questions. All offenses are offenses which would be committed where there is no reasonable excuse for doing so. I think that for me, I want to hear whether the commission, the directors, and the policy of the commission, if the information requested from a declarant is not an information that resides within the declarant's power to supply, and that declarant has made the request of the third party and has done everything that is reasonably required and expected of him, how do you deal with that? If at the end of the day the information is not forthcoming, but the information cannot reasonably be supplied by the declarant.
Thank you, Chairman. I just want to go back to a point raised earlier in terms of the naming and shaming. I just want to indicate that the matters on the list are not matters in which we have named and shamed. These are persons who have been charged, with the exception of one person, and so the conviction in and of itself is public. We do take the point, however, that it would be important to indicate that they have since been charged and convicted, complied with the requirements of the Commission, and we will take back these recommendations to the Commission. We are not, of course, opposed to whatever the committee suggests, and we will recommend them to the Commission when we get back. On the matter of whether the information submitted to the Commission satisfies the Commission, and whether the person who submits it has a duty to ensure that the information is satisfying to the Commission is something that would have to, I'm using a lot of satisfying, it is something that will have to be dealt with by all three of us, because, and I'm sure Director Beresford would have something to say, and the Director of Corruption Prosecution will have something to say. If the information doesn't satisfy the Director of Information and Complaints, certainly he will make the recommendation to the Commission for further necessary action. It comes to the Director of Investigation.
In all fairness, member, that point we have really hammered home. So let's hold it there.
Yes. When the referral is made to the Director of Investigation, an assessment has to be done to see whether or not it is reasonable that the information resided with the person and whether all reasonable steps have been taken by the individual to provide the information. So I'll have to clear that bar. And then it gets to the Director of Corruption Prosecution that bar has to be cleared as well, and she can speak on it. So it's not just a matter of one person making a decision as to what happens. It's several bars that have to be cleared, and if we're not all in agreement, it means that something is awry, and therefore the matter cannot proceed. So I leave it to Director Beresford to speak to the first instance in terms of originating the referral, the origination of the referral, and then the Director of Corruption Prosecution to speak about her role in the process.
Thanks, Chair. Yes, I want to address Member Malahoo for its question about information that does not necessarily reside with the declarant, and they would have to make a request to the third party. That's not unusual. Statutory declarations have been reviewed by the former Integrity Parliamentary Commission since '73. And now that we have subsumed into the Integrity Commission, we make the same request that we normally make. Once the information has something to do with your statutory declaration, we will ask you to provide the information. In the event that you say that it resides with another party, we give you sufficient time. Let me give an example. We started to examine a particular group starting September. 8 months after, we have not completed the group, and it's not a very large group. And it's because of the several extensions that they have asked for, and we have always granted the extension if it's reasonable. Now, I see some good things happening. I saw one financial institution sending out this particular memorandum to their customers, stating that within 24 hours of a request, and the Integrity Commission is also named, that you'll be able to get a response in terms of banking information, etc. Because we know banking information is the one that usually takes up some time. So I hope that the other institutions will follow suit, which means that if you, the declarant, provide the information up front, we have less questions to ask. It's just that the statutory declarations come to us, and most of the documents that should have been submitted are not being submitted along with the statutory declaration. So we still ask and we give time. So once it resides with a third party, there's no issue. So let me deal with the thing generally about information. Now, Section 32 of the legislation, sure.
In respect of a bank statement per se, but some information may require audited statements, or you're awaiting information from accountants, etc. So not all access to the information and the ease of accessing them, I don't think is same depending on the category of information requested.
That is well appreciated. We normally give the necessary extension. As a matter of fact, I know in about 2 or 3 cases that we have given up to 4 months extension for persons to prepare financial statements. I mean, that raises another question because the Companies Act would specify the obligations. However, we are not going there. But we normally grant the extension. There is never an issue with that. So let me go back to the functions. Very important, and I think I need to set it out. There are 3 specific functions of the Director of Information and Complaints. 1, I receive, keep on record, and examine all statutory declaration. 2, I make such inquiries as I consider necessary in order to certify and determine the accuracy. Because as you can appreciate, if you do not disclose your asset, I won't say you, a declarant does not disclose their asset, how do we know whether or not they have assets that they cannot explain? So it means that we are going to, as a matter of course, do certain third-party verification. Now, the statutory declaration form spells out every single asset that is owned, an asset class that is owned by any declarant. And we, as a matter of law, we have the obligation to ask questions and satisfy ourselves that all the information has been provided. Now, once all the information has been provided, and Member Warmington touched on that, and I'm satisfied that all, as best as possible, information is provided, then I will make the recommendation to the Commission to issue a certification. But the other important provision is 42.4, and this is where the Director of Information Complaints is of the opinion that an investigation in relation to a statutory declaration is necessary for the purposes of the Act. He shall refer the matter to the Commission for further and necessary action. So it's really 2 outcomes. You either get the certification, or if we believe that it's something that we need to probe a bit further, the recommendation is made. All right, thanks.
Philip.
No, I had wanted to raise on another matter. Are we satisfied with the, yes, please. Yeah, well, we're trying to clear the air in terms of what makes that trigger of certification.
So having issued your letter to say, quote unquote, I'm certified, what would then trigger after that the Commission going back to over that information, and then some point later I then get a letter to say there is a problem, even though you have issued a letter certifying me for this particular year or that particular year? What is the process there?
And that's a specific reason why we had to caution declarants to say that this is not an audit. Remember, when we are examining a statutory declaration, our reach is so far. Let's say, for instance, we certified your declaration in 2018. Then we got information that you have assets in China. We wouldn't have known before. Our reach is not necessarily that far. It would mean then that we would have to take that information, examine, and if we find it to be true that you really own that asset, then we would go to section 42.4, which is where we refer it to the Commission for an investigation to be undertaken. Because on the face of it, 1, you'd have provided false information, and 2, there may be questions about how you acquired those assets in China. So that's a specific reason why we cannot close it and utilize that certification. No, my eyes are going on the plaques, not you, Minister. So that's a specific reason why we cannot use the certification as a final piece of document to say that you cannot go behind it again, because we may get additional information that point us somewhere.
So short of you finding additional information, there really shouldn't be a reason, and there's a case, but I can't go there because it's sub judice. There shouldn't be a reason after receiving a letter that you would, quote unquote, reopen that particular matter. It's only if you, through your own investigation or whistleblower, there's additional information you find which is not in that declaration.
Sorry. Yeah, thank you, Chair. Remember, it depends on the offense. And I'm taking your cue. That's why I'm going to respond that way. I'm talking about examination of a statutory declaration where we find that you own an asset and we have to go back to determine how you acquired that asset and whether or not you misled the commission. So I'm going to keep the discussion there. All right? Thank you.
Members, I think before you do, I just want to advise that there is another meeting here at 12, the CDF committee, and then there's Parliament later on today. I think we've covered a lot of grounds in this regard. I think we've gotten a lot of good information that will help us to... No, I'm not preventing you, member, from speaking. Just respect the moment, yes, until I'm finished. Thank you. Right. So I think that we just have to be mindful that we do have to get out of here before midday so that the other committee can meet at midday. So go ahead now, member.
The recent reports submitted to Parliament have been primarily failure to file statutory declarations. Is this a major problem for the commissioners, for the commission, that people are not filing statutory declarations? I mean, is it a major problem?
It is no longer a major problem, but it is still an issue for us. Our compliance rate has moved. I can't speak about last year, but certainly for 2022, our compliance rate has now moved to about 84%.
Good.
We're coming from 30-odd%.
But
so
as I understand it, parliamentarians are 100%.
For that period.
22. Yeah.
2022.
You can't report on 2023. No.
Yes.
The other thing is, a few other little questions. My understanding is you soon will have electronic filing. Is that in place? That we just file electronically?
Yeah. We have been using the electronic declaration system since about 2021, 2022, internally, because we have been digitizing all the paper-based forms. We're about 80-odd% now for the years under the ICA, which is 2018 to present.
All right.
Very good progress. However, we wanted to launch it for the 2023 intake, but we have some other legal issues to just iron out. So all things being well and all things being equal, we should be able to have the EDS launch for the 2024. But notwithstanding our examination process that and we'll speak a little about this maybe at another time, Chair, because we did, some concerns were raised about the pace of examination, and we were asked to develop some strategies, and we have done so. So what we're going to require persons to do now, even before you're treated with electronic filing, that once we start the examination process, you will go on the EDS and you can upload the supporting documents. So it's much easier. If you get a scanned letter from the bank, you don't have to print it. So, it's removing that paper element. You can just upload the documents. We have the supporting documents. A lot of our processes already are automated by the EDS. So queries, looking at certain flags, etc., that is done by EDS.
Okay.
So we're utilizing it eternally, but for 2024, that is the target. That is where we would want to start.
All right, just a few questions to Mr. Stevenson. Without giving numbers, I mean, since the beginning of the year, I don't think we have had more than about 3 or 4 actual reports of investigations completed since this year. I think I can recall about 3 or 4 completed reports. It doesn't matter, but I just want to ask you, the next question is the one I really want to put. Do you, without giving numbers, do you have less than 12 or more than 12 investigations that you're conducting?
All right. Thank you very much, Member Chuck. Since the start of the year, you are indeed correct. There have been about it can't be 3 or 4 because all of these on the
No,
list
forget the statutory declarations.
You mean other
Yes.
investigation matters?
Right. I mean, you did one, for instance, the Charlemont matter.
I can't recall the number now. We are putting that together for the annual report.
Right.
We should have that the statistics. Well, I
think it's
can't
about
really
3.
report on the statistics for the 2023 period until after June. But last year, I think we had 81 reports coming to Parliament. I don't recall the actual number of statutory declaration-related matters compared to other improprieties in terms of the investigation reports. But that can be provided, and I think it is in the...
No, why I'm asking this, because it's clear, to the best of my understanding, I don't know, I'm just asking you, you're still investigating several matters for which you will write reports in due course.
Absolutely, Member Chuck. There are a number of investigations ongoing. Certainly, the statutory declaration-related matters, and when I speak about statutory declaration-related matters, I mean the failure to file, failure to provide information, and false statements. Those are usually easier investigations to be conducted because it's really paper-based. But in terms of offenses such as illicit enrichment, acts of corruption, these will take a longer time by virtue of the complexity of these matters. And I'm sure that very soon the Parliament and the country will understand the nature of some of these investigations just by virtue of reports that are produced from the work of the Commission.
Well, over the last 2 meetings here with Mr. Beresford, in relation to the so-called illicit 6, he indicated that this was a mismatch of what they said in terms of their income as against their expenditure. So it's a question looking at their statutory declarations. That's my understanding from, and in fact it's even in the minutes, where, you know, the report, what the minutes said is that it was a mismatch he asked whether the matter had been addressed. He stated that Mr. Beresford had previously appeared before the committee and had intimated that the basis of the illicit enrichment was a mismatch between purchases, expenditure, and income. Is that definitely the case?
Could I just correct that? Because I even saw it in the media and I was a bit taken aback. So it is really a mismatch between your assets and your income, not your expenditures and purchases.
Right.
Yes.
But for that year, or is it overall?
No. I wasn't specifying any matter and speaking about any specific matter. I was just saying generally that is what illicit enrichment is about, the mismatch between your assets.
No, but what I really wanted to find out, is this something that emerged from the statutory declaration, or is it allegations coming from third parties, or you know, under the Protective Disclosure Act?
Yeah. Well, you know, I would rather not respond to that, but I just want to say that it is a mismatch based on what we have seen. It's a mismatch between your income and assets, generally.
Well, you see, this is the reason.
All right, so but these are matters being investigated. I mean, but it's over a year now.
I would prefer, Chairman, through you, to refer to the definition that is given in the law as it regards illicit enrichment, and it is when a public official owns assets disproportionate to their lawful earnings. Now, the statutory declaration is one tool, only a tool, from which you may be able to have an indication as to whether there is illicit enrichment. The examination that is done may give an indication that something is not right, which of course needs to be investigated. There are several reasons that I could think of why your assets could be disproportionate on the face of the document. And that is why an in-depth investigation has to be conducted to see whether on the face of it, there is actually an offense, or there is just information that you may have failed to provide that would explain. And that is why when the matter of illicit enrichment is being investigated, the declarant must give an explanation, or is required to give an explanation as to how they came by those assets. Without that, it's very difficult to proceed. Now, the other question that was asked by Member Chuck is whether all of this comes from just the statutory declaration. And I just refer to what I said earlier, that the statutory declaration is one tool. That's the principal tool that this jurisdiction uses for public officials to declare their assets. Now, there could be an allegation. Somebody could come to the commission and say that person X owns all these assets and so on. And we would have reason, depending on what is said, to consider whether this is so. This could also arise in the course of investigating another complaint. You know, from time to time, you may be investigating just another irregularity or some complaint as to an act of corruption, and you have a reason to consider the assets, income, liabilities. And of course, the work of the commission is joined up in that way, and we have to, of course, interact with the Director of Information and Complaints in order to be able to investigate that kind of complaint, if that answers your question.
So in that context then, would we be ready to say that the charge of illicit enrichment is appropriate while we are seeking to determine whether the third-party information is accurate or, in fact, the seeming mismatch of income and assets and so on, and the declaration is there? Would it be a fair statement then to say that a charge of illicit enrichment has been levied? That's the point. Exactly. But illicit enrichment is an outcome. Exactly. So you would be investigating to enable you to determine whether there is illicit. So therefore, there isn't a case where there's illicit enrichment on the part of any, but rather that there is a question of determining whether or not illicit enrichment has been. No, what I'm saying. So what I'm saying, do you say that as an outcome, or do you indicate that investigations are taking place with regards to this? You follow?
Yeah, yes, Chair, but that is specifically what is done. We just indicate that it's a referral, and it's a referral that on the face of it we have seen either that the person may have provided false information.
Right. But the referral, as Kevin correctly said a while ago, could be from a third party, and you are really just determining whether that third party allegations have a foundation or a basis for you to move forward.
Yeah, but normally, Chair, when that is done, for instance, if we get information to say that, say, a member, well, a declarant, let's say a declarant has certain assets that they have not disclosed, before we even move it and make a referral to investigation, we double check, because we have these third-party databases that we can check for ourselves.
Clarity here is that you do not make a statement with regards to illicit enrichment until you are certain that there is the basis for this.
On the face of it, the commission would have made the determination on the face of it.
No, I was just asking the question, when is the annual report due to be tabled in Parliament?
The 30th of June, that is when it becomes due. I'm sure it should be before you around that time.
No, I was just saying that all the annual report mentions is an investigation. Now, it can go either way. At the end of the day, nothing may come out of it. And so in the next annual report, instead of X, you say X less than X. Or if it then something comes out of it, then there's a referral to the Director of Corruption Prosecution. Yeah. Yeah.
Excellent. I think we've had a fairly good, please. We are at 11:44 members, and we do have another committee to meet in this chamber at 12 and Parliament at 2. And I think that I did not say we're disallowing. I'm again reminding members. Yes, and in fairness, we have gone far beyond what is the normal examination that we do for these reports. So please, Member Malahoo Fort, let's bear what I just said in mind. Thank you.
Chairman, on the matter of statutory declaration, I don't have the act before me now, but who considers the statutory declarations of the staff of the Commission, and in particular the directors, and who would perform the functions of the directors in the event that the need arises? That's the first question. And the second question is, who deals with the statutory declaration of the commissioners? And certainly at least one who I know the Auditor General as a public servant has to submit statutory declaration. Who deals with those, with her declaration? These are matters that are asked repeatedly in the public interest, and on which we will have to at some point have some discussion. Thank you, Chairman.
Yes, thank you, Member. On the issue of the commissioners, there's a legal opinion on that. We had placed it on the table from, at the last Integrity Commission Review Committee meeting, Integrity Commission Act Review Committee meeting. As it concerns the staff of the Commission, we have, and in particular directors, we have made recommendations again to the Joint Select Committee reviewing the legislation. So it is before them. Well, the declarations are with us, secured, until it is settled.
At all? None of the declarations?
Well, and that is why we have made a recommendation, because internally...
I didn't hear the answer first.
Yes.
Have the statutory declarations of the staff of the Commission, and in particular the directors, been reviewed at all? That's the first question. And then the second, you would say, what you say is before us.
The answer is no. We have not reviewed them because, in our opinion, we believe that the inherent conflict with, we reviewing our own thing. And that is why we made certain recommendations to the Joint Select Committee. So,
and then we are looking at that wearing another hat. And in fact, we're looking at other jurisdictions to see what obtains there and how it can be applied here. Member Malahoo Fort, I see you are again asking, but I urge you to...
Last point for the record is that in the other place, the matters relating to recommendations to deal with those statutory declarations must be dealt with expeditiously.
So that's for the world at large, not for this committee. Thank you. Mr. Beresford, sorry, Mr. Stevenson, you are the leader. We want to thank you for attending, and you've really been very helpful, I think, in explaining a number of areas and provide further elucidation on matters that have been a little concerning to members. Thank you very much. You wanted to?
Yes. You're very welcome, Chairman, and I thank you and the committee for hearing us this morning. And I have recorded here two major recommendations to take back to the Commission. One is to make a report to this committee as to the standing of persons who have been charged for their failure to file statutory declaration and other connected matters, as well as for the ruling in relation to persons who, for whom recommendations have been made to be charged, to be provided to the Houses of Parliament so that it can become available to the members and the public. So we will take those back to the Commission for their consideration.
Members, for the purpose of our reporting to the Parliament later today, we have the 6 reports, as indicated. 7, yes. The Ava Williams one that came after, yes, of course. The 7 reports. Is it the wish that the Parliament be advised that we have reviewed and found them satisfactory? Yes? Thank you. Yeah, we just said that. And so we put in a little pressure on the secretary here to do the report in time for this afternoon's meeting of Parliament. So do I have the motion? This meeting is now adjourned for a date to be fixed.